following information is provided by the People's Property Rights Central Association and is for educational purposes and is put together in order to help those that seek to overstand the fraud in the mortgage process that is used today and to stand up to those that attempt to steal their property away from them. This information is in raw outline form and must be composed in an organized and intellectual fashion in order to represent your specific situation. The speaker does not know your specific situation and implores you to vet and know your agreement so that you are aware of your specific situation and that you may be the master of it. The speaker only makes claim of ownership to the images previous to this slide and no other. You may make use of any information provided herein that you deem useful and applicable to your situation. And please be masterful. Now, illegal activities exist in the majority of all mortgage transactions today that are facilitated by National Association banks. And I know that this is a very serious claim, and I don't take that claim lightly, but I do have evidence to support my claim. Now, many people today are misinformed when it comes to mortgages today, and that's mostly due to miscommunication or actually the misdefinition of words. And what I mean by that is that typically we have a common definition of a word that we use in common language, and we don't realize, or we fail to realize, that the terms of the agreement and the contract that we sign actually define the very words that we use in a different fashion. And what compounds that is that sometimes courts have an even different legal definition of that same term. Now I'm going to take a look at a couple of different words, and let's go over those definitions. Let's look at the word loan. According to the New World Dictionary of the American Language, 2nd edition, a loan is the act of lending, especially to use for a short time. Something lent, especially a sum of money, often for a specified period and repayable with interest. Now, according to Black's Law Dictionary, 8th edition, a loan is an act of lending, a grant of something for temporary use. Now let's switch it up a little bit and look at the word exchange. And now, according to Black's Law Dictionary, 8th edition again, under commercial law, the exchange means the act of transferring interest, each in consideration for the other. Money, negotiable instruments presented as payment, see currency, see medium of exchange. The interchange or conversion of money, see foreign exchange, the payment of a debt using a bill of exchange or credit rather than money. Again, that's Black's Law Dictionary, 8th edition. Now I want to take a look at a couple of quotes in a couple of different publications that are distributed by the Federal Reserve banking system, specifically the Central Bank of Chicago, and the first being Modern Money Mechanics. And on page 6 of Modern Money Mechanics, what they state is, what they do when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction accounts. Now the second publication that I want to take a look at is entitled Two Faces of Debt, and that is also published and distributed by the Federal Reserve System, specifically again the Central Bank of Chicago. And on page 21 it states, or I quote, but a depositor's balance also rises when the depository institution extends credit, either by granting a loan to or buying securities from the depositor. In exchange for the note or security, the lending or investing institution credits the depositor's account or gives a check that can be deposited at yet another depository institution. In this case, no one else loses a deposit. The total of currency and checkable accounts, in other words, the money supply, is increased. New money has been brought into existence by expansion of depository institutions' credit. Again, that's page 21. Now, foreclosures are inevitable in a debt-based economy system because recessions are built into the cycle. Now, the majority of foreclosures today that happen in today's economy are actually invalid and illegal, and most foreclosures actually violate people's property rights. You know, if you look at the United States Constitution's Amendment 5, 14, Section 1, and even codified at Title 42 United States Code, Sections 1982 and Section 1983, as well as Title 18 United States Code, Section 242. Those are interesting if you look at the rights that are codified there. Now, the right to due process must be waived knowingly and voluntarily. It cannot be done accidentally or incidentally. And this is by Miranda v. Arizona. It was established in 1966 by the United States Supreme Court. Now, constitutions actually protect the rights of people from the government. And even though it's a bank that's attempting to foreclose, the bank has to evict you by way of a court order. Now, that court order can be through an unlawful detainer action if you're in a non-judicial state, or if you're in a judicial state, then they have to take you to court in order to get you to comply with the terms of the agreement that you sign, i.e. the promissory note or mortgage. Now, here's an important piece, is that the lenders constantly violate the terms of the agreement. You executed a promissory note that is payable to a specific bank, and there are terms that they must uphold and adhere to within those agreements. For example, one of the terms of obligation is, I understand the lender may transfer this note. The lender or anyone who takes this note by transfer and who is entitled to receive payments under this note is called the note holder. Now, if you look under the section entitled Borrower's Failure to Pay as Required, it states the following. If the note holder has not received the full amount, etc., or it also states, if I am in default, the note holder may send me a written notice. The common theme, note holder. Under the section of obligations of persons under this note, by signing the promissory note, you agree to be obligated to make payments to the note holder. Period. The note holder may enforce his rights under this note against each person individually or against all of us together. Under the section that's entitled Uniform Secured Note, in addition to the protection given to the note holder under this note, a deed of trust protects the note holder from possible losses. Now, that's obviously in non-judicial states. Now, by the terms of the agreement, you agree to be obligated to the note holder. If there is no note, then there's no note holder. By the terms of the agreement, you only agree to pay the note holder, and if the one demanding the payment is not the note holder or someone who represents that note holder, then you have not defaulted them. Now, let's get back to this piece. Foreclosures, again, are in most cases illegal and invalid. If you note, each and every public servant, a judge, police, sheriff, bailiff, I don't care if it's a meter maid, they're required to take an oath of office to uphold the Constitution for the United States in whichever state in which they perform the duties of their office. Again, if that's if they're a public servant. Now, corporations do not possess unalienable rights, which are protected by the Constitution, but you do. Now, why don't we use that to our advantage? Again, the United States Constitution, Section 5 or Amendment 5 and 14, and also codified it, as previously stated, United States Code Title 42, Sections 1982 and 1983, as well as Title 18, United States Code in Section 242. And again, I mention those again because I strongly suggest that you read them. And if you also look at your enabling act of your state, every state has an enabling act that puts certain conditions upon their entry into the Union. One part of it reads, the Constitution shall be republic in form and make no distinction in civil or political rights on account of race, color, except as the Indian is not taxed, and not be repugnant to the Constitution of the United States and the principles of the Declaration of Independence. And said convention shall provide an ordinance irrevocable without the consent of the United States and the people of said states. Now, I won't read the rest of it. You can again pull up your enabling act. I think it's very important that you read it. Just my opinion. Now, long ago, the United States Supreme Court ruled that the security instrument, i.e. the deed of trust or mortgage, must remain connected with the instrument that it secures, i.e. the promissory note. The note and mortgage are inseparable, they said. The former is essential, the latter as an incident. An assignment of the note carries a mortgage with it, while an assignment of the latter alone is a nullity. This is a case entitled Carpenter v. Longan, and though it was established in 1872, it has never been overturned by the United States Supreme Court, and there has never been a law that has overturned it. And by the prime directive, i.e. the Constitution, it cannot be overturned. And here's why. Because Article 1, Section 10 states in part, no state shall pass any law impairing the obligation of contracts. Now, I think it's also important to note that in that the judges further stated, we think the doctrine we have laid down is sustained by reason, principle, and the greater weight of authority. How about common or divine sense? Now let's look at a little part that, again, I stated that many of the mortgage processes are actually illegal, and securitization is a part of that. Very simply put, securitization is the sale or investment and transfer of interest in a promissory note to a pooling trust. Simply put, a group of promissory notes are placed into a trust pool, and the lender is no longer the holder of that note, or no longer that note holder. So let's imagine this. You have a trust, and so instead of a trust, let's imagine something tangible like a bucket, and that bucket is the trust that holds the items inside of it. And let's say that promissory note is the instrument that is held inside of that bucket or trust. Alright? Now you have another trust over here to your right, and that's the pooling trust. So you take that promissory note or that instrument out of the first trust, which is the deed of trust, and put it into the second. And what do you have? You have a empty or a vacated trust. It's unenforceable. It's vacated. So the terms of that agreement of that so-called deed of trust or mortgage is no longer valid because they've been separated. If the promissory note was taken out of the deed of trust and put into an asset-backed trust pool, that also means that they've been tendered payment. The trust deed or deed of trust no longer secures the promissory note and is therefore unenforceable. Now let's talk about a couple of the crimes that have been committed here. Recording false or forged documents in the public record. That trust deed or the notice of default that you've gotten, that you received, is invalid. It's false. They've committed mail fraud by sending you a statement that you owe them money when you actually don't. Again, they're not the note holder or don't represent the note holder. They're a violation of other laws, not limited to, including but not limited to, again, Title 42 United States Code 1982 and 1883, as well as Title 18, Sections 241, Sections 242, and even 1341. Look those up. How about enrichment? Now, all judicial actions must be brought in the name of the real party of interest. Simply put, this is the note holder, and if they are not the note holder or don't represent that note holder, then they are not the real party of interest. They don't have standing. And by claiming such, what have they done? Are they bringing fraud upon the court? Now, really quick, I want to insert something here. When the lenders actually transfer that note over to a trust pool or asset-backed pool, the investors actually tender money to them or provide monies to them as an investment, which means again that they've been tendered payment. Have they received that payment on the full disclosure? Can you say TILA violation? Know your contracts. You have to know and read your contracts. And then when you know and read your contracts, make nice demands of the servicer and ask them specifically to provide the name and address of the note holder. You can even state that you want proof that they and personally want to inspect the promissory note. Now, don't ask them to send you the promissory note. They're not going to do that. If they send you the original wedding genuine promissory note, they are no longer the note holder. They're not going to do it. Now, when you do this, you can ask for a mediator or a mediation and to expect the note in front of a disinterested third party. And then when you do that, you want to be aware of tricks, color copies, computer-generated forgeries, even affidavit of lost notes. And if they do provide an affidavit of a lost note, then guess what you do? You simply question the one that attested to the affidavit. You can question this: where was it stored? What was the process that you entailed or that you followed in order to search for the promissory note? How long did you search for the promissory note? And where did you search for the promissory note? Demand that the judge uphold your right to due process. If they don't have the note, then they don't have a contract with you. They're not the right to the note holder, or they don't have the right to the note holder, and they don't represent one. So demand that he uphold your right to due process and uphold him to his oath of office. Simply put. This video has been presented to you by the People's Property Rights Central Association. We want to thank you for your time, and we hope this gets you on the right track. We provide education for people by sharing more detailed information on how to stand up and protect them from this very thing. You should read and understand your contracts and consult with knowledgeable people that can assist you in standing up to keep what is yours from any type of trespass or against your right to your home. Be blessed and be masterful. You can reach us at www.don'tgiveupyourhouse.com. Be blessed and be masterful.